Yes, please.
I'll be starting on the self count of 3, 2, and 1. Imagine you are an artist. You have spent 10 years learning your skill, learning how a brushstroke feels, how colors speak emotion, and how art pieces can be brought to life. And one morning, you wake up and find that a machine trained on your paintings, your sketches, and your life's work is now selling art that looks exactly like yours. And nobody asked you, nobody even paid you, nobody even told you for that matter. This is not hypothetical. This is happening right now. The rise of AI exposes a fundamental gap in our legal framework. IP law has always been built on the assumption that human creativity, which is being challenged now by AI. This leads us to today's central question. Can a machine be considered a creator? AI is based on ML and neural networks, systems that learn from large data sets. Generative AI models are designed to create new content by identifying patterns in existing data. GANs involve two competing neural networks, a generator that creates the content and a discriminator that improves the content. IP primarily has 4 pillars. AI puts pressure on each one of them. The fundamental similarity in the legal framework is that each one of them is a human creator, assumes a human creator. Key points of thought here are: who owns the AI generative creative content? Can AI generated inventions be considered for patents? There are 3 approaches to authorship in AI generated content: the user, the developer, and the third, no one. On the basis that copyright requires human authorship, the US Copyright Office has confirmed this. The federal courts in Thaler v. Perlmutter in 2023 and the 9th Circuit courts in Naruto v. Slater established that non-human authors have no copyright standing. AI models are trained through multiple stages: data acquisition, data curation, model training, and deployment. In 2023, we saw New York Times suing OpenAI and Microsoft, stating that millions of articles were used to train GPT models without authorization. Now, fair use doctrine legally allows certain use of copyrighted material without requiring permission from the original creator, and the legal bodies consider these 4 facts to consider whether fair use is being applied or not. Now, coming to solutions. There are 3 types of licensing that we can give to authors. First, voluntary licensing, collective licensing, second, and third is compulsory licensing. Coming on to various technological solutions that we can give to authors, it includes adversarial perturbations, which include introducing some changes to AI generated content through which we can identify that this content is AI generated. Second, digital watermarking. Third, attribution techniques such as spectral fingerprinting, in which experts use something called a discrete cosine transformation to trace which AI model has generated this content. Alongside, we have safeguards. For example, AI can replicate an artist's style with precision. So style imitation, deep fakes, economic disruption. But we also have to consider AI assisted creations, because at the end of the day, it is a human who is assisting AI to generate something that it is generating. Coming on to policy recommendations, which we need to apply at a global level. We need to establish clear definitions of what constitutes AI generated work. We need to establish scalable licensing frameworks. We need greater transparency in training data. And finally, we need international and global cooperation to ensure consistency across countries. Finally, the goal of intellectual property has always been to reward creators so they keep creating. AI did not break that goal, but it has broken the tools that we use to achieve it. The artists who spent 10 years learning this skill deserve to know that the law will catch up. The question is not whether AI and creativity can coexist. They are already coexisting. The question is whether justice can keep up or not.
Question. You brought up artists multiple times. Is there any IP protection for a particular style, or are there any limitations that you see in how copyright exists?
Basically, from what I read in some of the papers, and even on internet in general, over the past, when we talk about primitive art forms, people have been learning from each other's art forms, right? If I see someone art form, I learn something new. I see multiple art forms, I learn different new things. So what I create as my own creation, even as a human without using AI, could be influenced by a lot of artworks. So now this is like a very thin line between what is copyright infringement and what is my inspiration of other artworks created as mine.
So interested in that idea, Krishna, talking earlier, looking at copyright protecting expression. My question is, and we can probably discuss this later, is that copyright protect may not cover style. What I'm trying to talk about is what does copyright actually cover? It covers expression. It may not cover your individual style. So one of the major challenges in this space is that when an AI model is reproducing your copyrighted content, is reproducing your style may not be individually protected as copyrighted piece of work. Something for you to think about because when you're thinking from an artist's lens, when you think deeper in terms of what can an artist protect under IP laws.
What I read was that, for example, I have like my artworks going all over the internet, and let's say it is being used as a training data set for multiple artificial intelligence models. Now, if AI is generating a different artwork, how would I know that my artwork has not been infringed? So what I read about that is that, what I also mentioned in my speech, DCT, discrete cosine transformation, it breaks down the image into different frequencies, and based on that, we can check if the same exact frequency from my artwork was picked or it was modified a bit. So that is a part
that
of like
your policy, technology, and solutions is good.
Any more questions?
Thank you.
You mentioned about policy recommendation that to establish a clear legal definition of AI generated. Just a very simple question. The use of AI as such or generative AI is not problematic.
Definitely.
So if we have to define, let's suppose you are a policy maker, as a policy maker you have to establish that clear legal definition. Now, how much use of Gen AI would be problematic?
Basically, the use, as you also mentioned, is not problematic. The problem is where the AI starts to take exact copies of a person's already copyrighted data. For example, as I also mentioned about my main research was for artwork. So if the same artwork's frequencies are being replicated, then that can be considered as completely generative AI copyright infringement. But if AI models learn, for example, I mentioned about neural networks, they read through like billions of data sets and they learn like patterns through which they can generate new data. So that is not exactly copyright infringement, but that can also not be morally said that it's generated completely through AI. So it's a matter of like discussion, and also research as well. So it's being deliberated upon.
There are 2 pointers I will suggest you think over. Number one is transformative effect. Okay, you are saying that if you are creating the same work, whether that transformative effect is generated or not, that is a thin line which you need to appreciate. Number 2 is whether AI can copy everything. I'm coming to his question, that is style, isn't it? Even if you are reading a book and AI is reading a book, isn't it? So whether the same flair could be copied or not, that is something which you need to identify. For you, I'm just asking that look into those areas also. What is the limitation of AI, isn't it? Good presentation. Thank you.